The Bar Association conspiracy, the illegal monopoly of the legal profession. The fraud of the bar card and the practice of law as a common right. How private lawyer unions usurped control of the American judiciary. The unconstitutional title of nobility and the black robe cult. Reclaiming the Sixth Amendment, assistance of counsel without limitation. According to the United States Supreme Court, the practice of law is an occupation of common right and cannot be licensed by any state. Decisions such as Schwer v. Board of Examiners and Sims v. Ahern established that a certificate from a state Supreme Court only authorizes an individual to practice law within the courts as a member of the judicial branch. This authorization is technically limited to representing wards of the court, such as infants or persons of unsound mind. The bar card is not a state-issued license to do business as a law firm, rather, it is a private union dues card for a professional association. Unlike doctors, whose licenses are issued by the state, lawyers belong to a non-governmental private association that maintains an unconstitutional monopoly over the legal system. The American Bar Association is an offshoot of the London Lawyers Guild and was incorporated in Illinois in 1909. This private organization successfully lobbied state legislatures to pass unconstitutional laws requiring all law enforcement and legislative positions to be held by its members. This allowed the bar to invade all branches of government, violating the separation of powers and creating a system where agents of a foreign entity control domestic policy. By the 1930s, this treasonous arrangement became de facto across the nation. This system allows lawyers to guarantee outcomes for a privileged class, replacing plain English constitutional laws with complex codes and the subjective opinions of judges. In states like California, the government has no actual jurisdiction over the Bar Association. The bar accredits its own schools, conducts its own examinations, and keeps all associated fees. It also selects the candidates for judgeships and is the only entity with the power to discipline its members. This concentrated power in a private union headquartered in Illinois is contrary to both state and federal constitutions. The judicial branch has effectively created case law, which is an unconstitutional usurpation of legislative power. When lawyer judges instruct juries or strike evidence from the record, they are tampering with the truth, turning juries into puppets and ensuring the trial is rigged in favor of the corporate legal system. The use of the title officer of the court constitutes an unconstitutional title of nobility, creating a first-class citizenship for lawyers while relegating non-lawyers to second-class status. This black robe cult operates in foreign tribunals where constitutional protections are replaced by extortionistic litigation known as barratry. While the Sixth Amendment guarantees the right to the assistance of counsel, it does not limit that assistance to licensed lawyers. An accused individual should be able to choose anyone for assistance. To restore a republican form of government, the people must dismantle this monopolistic enterprise and return the courts to the sovereign citizens, ensuring that no ruling class holds exclusive power over the administration of justice.